there have been proposals to amend the 14th Amendment to the Constitution, specifically the Citizenship Clause. For example, House Representative Lamar Smith, a Republican from Texas, introduced House Resolution 1868, known as the Birthright Citizenship Act of 2009, and what that act seeks to do is to repeal birthright citizenship and only afford to those children born to at least one parent who is a U.S. citizen, a legal permanent resident, or an undocumented immigrant serving in the military, birthright citizenship.
With Dred Scott still on the books, there were serious doubts as to the power of Congress to make blacks citizens of the United States by statute. Although they tried it in the 1866 Civil Rights Act, you would have to say that they got their power to do that from the 13th Amendment, which abolished slavery, and considering what we just said, that slavery and race had been put into the same ball of wax, that was a pretty dubious constitutional argument. And that is why Congress, anticipating a hostile Supreme Court once the South was readmitted, took the language that they had put in the 1866 Civil Rights Act and inserted it into the first section of the 14th Amendment, which you saw, to overrule Dred Scott's interpretation of what citizen meant in the Constitution and say that all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside. And the effect of that was to prevent what would have happened if Dred Scott had remained the law, namely you would have had a system of apartheid. Right? Generations of people growing up here, but permanently excluded from the political system, including access to the federal courts, no matter how many of them there were and how long they stayed, literally what the South African system was. And since here, unlike South Africa, blacks were going to be forever a minority, they had to be made citizens by the Constitution, not just by permitting Congress to do it by statute. The 14th Amendment couldn't have said Congress has the power to make anybody it wants citizens, because that was never going to happen in Congress, because blacks would be a permanent minority. And to its credit, the Supreme Court has always understood precisely this, which touches upon the whole idea of discrete and insular minorities, which Professor Friedman will be talking about. And the Supreme Court's decision in Wong Kim Ark, which was the first time that the Birthright Citizenship Clause came up in a litigated case, paved the way for the integration of successive waves of immigrants, Italian, Irish, Poles, and many others, who all suffered serious initial hostility, but were quickly absorbed into the fabric of the country once they became voters.
The issue of the children of illegal parents came before the Supreme Court in a different context in the case of Plyler versus Doe. Do you want citations for all of this? 457 U.S. 202. And the case is very interesting, was that the children born abroad who come to the United States are still within the jurisdiction of the United States. And therefore, as every other person, they are subject to the Equal Protection Clause. And if you deprive children of the right to an education, that is a violation of the Equal Protection Clause, because denying children the right to an education, which every other person, whether you're a citizen or not, is entitled to, is subject to heightened scrutiny. So rather than apply strict scrutiny, they took the intermediate equal protection scrutiny and applied that to this case. But somewhere in the case, in the famous footnote 10 of Plyler versus Doe, they talked about the first sentence, the natural-born citizenship provision. And they said, footnote 10, although we have not previously focused on the intended meaning of this phrase, namely the citizenship phrase, we have occasion to examine the first sentence of the 14th Amendment, which provides that all persons born and naturalized and subject to the jurisdiction thereof, ital, to see what does that mean. But I mean, it's very clear in both the Wosamar case and in Plyler versus Doe, that the Supreme Court has given the broadest interpretation to the first sentence of Section 1 of the 14th Amendment. All persons born in the United States and subject to the jurisdiction thereof, excluding only this very narrow group of people that the English common law had decided to exclude, are citizens of the United States, period.
Many in the United States have argued, as Professor Leon Friedman has mentioned, argued for amending our law so that a child born in the United States must have at least one parent who is either a citizen or a legal resident. Opponents of the proposal have underscored that the biggest stumbling block to repealing the citizenship clause or changing the terms of the citizenship clause is precisely what Professor Eric Friedman mentioned, right? The text of the 14th Amendment explicitly provides that being born within the United States and subject to the jurisdiction thereof confers birthright citizenship on that particular person. Moreover, the Wong Kim Ark explicitly recognized that persons whose parents are not residents or not citizens of the United States may still acquire birthright citizenship. However, there is an opposing view, and this view argues for a reinterpretation of the 14th Amendment citizenship clause. So we don't need to amend the 14th Amendment according to some scholars. What we basically need to do is just to go back pre-Wong Kim Ark and look at precisely what Congress intended at the time when it passed the 14th Amendment. But the framers knew that it would confer citizenship to persons other than African Americans. At the time that it was being debated, there were a lot of Chinese immigrants who were already in the United States, particularly in the West Coast, building railroads and working the gold mines. They recognized that these Chinese immigrants will have children, and to expressly limit the 14th Amendment only to the slaves or the freed slaves will be contrary, according to some of the Congress, based on the debate, that it would be contrary to the principle of equality that they were trying to invoke through the Equal Protection Clause. I just wanted, I think I have about 2 minutes, wanted to highlight some policy concerns about the current proposal. There are 5, and I'll say them first, and then at that point I'll discuss each one of them at greater length. So one is the racial implications of the proposal. There is no doubt that the significant percentage of undocumented immigrants are people from Latin countries, from Mexico specifically, which has the greatest number of population of undocumented immigrants. So there are racial implications of the current proposal. Second, policymakers have argued that it will not solve illegal immigration problem. Third, it will create a caste system in the United States that is inconsistent with the Equal Protection Clause. Fourth, implementation will be extremely difficult. And then 5, immigration law is highly complicated, and it would be, from an efficiency perspective, it would be complicated and burdensome and costly to try to implement this the proposal. So one, racial implications. I think, as Professor Friedman already mentioned, there are some racial implications here. What was done in Europe and the changes that transpired in the UK and in France are similar to what has been going on here. There are if you look at YouTube or if you read some of the articles, many of the proponents of repealing birthright citizenship have focused on persons who speak Spanish, and even if there was no actual intent to deprive primarily Mexicans from obtaining citizenship under the United States, there is a disparate impact, but just by the sheer numbers. And so for those of you who are already familiar with disparate impact theory, then that a particular law that has a disparate impact on a particular population will be contrary to principles of equality.